At the current time, the only products that are involved in talcum powder lawsuits are Johnson & Johnson's baby powder and Johnson & Johnson's shower to shower. Now, on May 19, 2020, Johnson & Johnson announced that it would discontinue the sales of its baby powder containing talc in the United States. I would suspect that that product is generally not available in the United States any longer. In addition, now as to Johnson & Johnson's shower to shower, that product was owned for many years by Johnson & Johnson. In 2012, Johnson & Johnson sold shower & shower to Valiant Pharmaceuticals. And in 2019, the last shower to shower with talc was distributed. Since then, in the shower to shower product, it's been cornstarch as the active ingredient. So since about February 2019, give or take, depending upon the store inventory, all the shower & shower products now have cornstarch instead of talc as the active ingredient. Well, there's been a number of lawsuits already. I think the first one was in February 2016, where the jury awarded client $72 million, including $62 million in punitive damages. A few months later, in May of 2016, the client was awarded $55 million against Johnson & Johnson. And then in November of 2016, California jury retained $70 million for the client. The following year, in 2017, there was another award in Missouri of $110 million, followed by, in August of 2017, a $417 million verdict. And then there's been other verdicts in April of 2018 for $37 million, May of 2018 of $25 million, July of 2018 for $4.6 billion on behalf of 22 women, where the court put 22 separate individual lawsuits in one trial. The court's reasoning is that a lot of the scientific background and general causation testimony really affected all 22 cases, and that the court then let the lawyers offer the individual damage evidence to each of the 22 women separately. In March 2019, there was a $30 million award, and there's been probably others as well. Over the years, certain talc cases have settled. Not too many, but just before trial or just into trial, certain cases have resolved. Certainly not enough, and maybe that will be happening in the future, but we really don't know that yet. You should definitely be talking to your doctor about your injury and any signs and symptoms of ovarian cancer or mesothelioma that you might be experiencing. You should be talking to your doctor about your diagnosis, about your treatment, about anything that's essential to your medical condition. However, you should not be talking to your doctor about the litigation. You could be deemed to have waived your attorney-client privilege by making such disclosures. And in that regard, you should not be posting anything about your injuries or your lawsuit to any social media account. For example, if you have a Facebook account, you should not be posting anything to Facebook. Defendants are generally entitled to any relevant posts on your social media, and you don't want anything on your social media that's going to affect your lawsuit. So just don't do it. Don't post to social media. Everything you tell us about you and your case is confidential, and it's protected by the attorney-client privilege. However, once we file a lawsuit, the lawsuit itself is a matter of public record. Almost every courthouse, somebody can go in and do searching, and they could find the litigation, they could find the paperwork. But It's unlikely that they're going to find any medical records. Those aren't going to be filed in the court record. But the fact that you are in litigation, if somebody wanted to go out and search the world's records regarding you on the internet, theoretically they could do it. It's a little difficult, but it can be done.